Good afternoon, everyone. It's a great pleasure for me to speak to you today. And as just noted by Alexei, Ukrainian companies have won tenders before abroad, and actually they have good opportunities now, but this is new markets for them, and it's like 46 new markets, and in preparation to enter in 46 new markets, you need to really do some homework, and for this you need to do research and maybe many changes in your current way you are doing your product or your services, and for this you may need either consultants or partners abroad. So the first thing that it is important to understand that the markets that GPA opens are highly competitive, and in competitive markets you really need to first to do the assessment of the market itself and potential of your product, and to know your competitors, and the second you need to analyze the product in a way how much changes or how many changes you need to make. Maybe you need to change your marketing policy, maybe you need to change your product, or certain requirements to your product should be uplifted and your product should be upgraded. And then you need to assess logistic and cost-benefit analysis and search for potential partners or assess whether you can enter this market yourself. So I wanted to start with this because the market entry consultancy, whether you can do it with outside consultants, these are not lawyers obviously, but finance consultant companies, or you can do it with your own forces inside your company. But this is very important because participating in foreign tenders, it can be very expensive actually and administratively cost procedure, because you may need a performance guarantee which costs money, you may need a deposit, you may need to pay a fee, you may also waste a lot of time and energy preparing the tender documentation, especially if you have very sophisticated tenders for certain works or design products. So first step in preparation for participating in any public procurement abroad, which are even more sophisticated than entering an order market, would be to do, let's say, a market analysis and understand your business model and understand how competitive you are and which countries you need to approach for public tenders and at what level. As discussed earlier, yesterday and today, that not all tenders are centralized, especially in the European Union. You have many layers of tenders, and to understand at what level, at level of what company or centralized level you can bid is really important to do this homework. It's even not legal assistance. This is more, let's say, organizational assistance you need before entering the market. And if you are well prepared at this stage, then there are good chances and it's easier to go to the next stage and actually to do the preparation, formal preparation on the legal issues you might have. And I'm just curious, do we have here any company who already participated in public procurements abroad? Not a single one. Are you preparing? Is there a company who preparing? Okay, there is one company preparing. We are currently having a client, assisting a client, preparing to add for public procurement procedures in a number of jurisdictions, including the GPA jurisdictions, but not exclusively. And it appeared to be a great work, just not on procurement issues like we discussed, but on general legal issues the company has to face. And of course, these are requirements to the goods and the services, because any procurement requires that the goods should comply with the local legal requirements, the services or the works. And this contains certification, licensing, environmental safety requirements, which requires the company to know a lot about the local market regulations. Then it's taxation and custom duties, because sometimes because of local tax and custom rules, it's easier for the company, for example, to bid not from Ukraine, but maybe from a nearby country, to find a partner in the country or a nearby country, or maybe and establish a subsidiary or representative office, just for the purpose to make sure that the goods can be competitive, even not on the level of procurement, but generally on the level of this market. Then,
can we ask him to slow down just a little tiny bit so the translators?
Okay, sorry. And another issue is understanding mandatory rules, and this is the most important are defect liability and competition rules, which often can be violated because we have different defect liability rules and competition rules in Ukraine than in other countries, especially in the EU and the US, and the companies can be disqualified from the tenders based on these requirements, on breach of these requirements. Compliance and anti-corruption laws. So if you're already participating in foreign public tender, you are subject to compliance and anti-corruption laws of that country. And it's very important that the company is compliant and has a good track to be a competitive bidder. Then understanding of dispute resolution, practice on supply, insurance, logistics is also would be helpful, because then you can plan your cost, allocate risk, and also create an effective business model and legal model for supplies, and of course currency control and restrictions on payments. And here it's important to understand that not only Ukraine has currency controls which actually limit possibilities of direct participation of Ukrainian companies in public procurement. So if we think of the deposits, we will think of Ukrainian currency control legislation, and even participating in procurements when a guarantee is required from an international bank, for example, a foreign bank with a certain rating, it's also an issue for a Ukrainian company. But on top of this, certain jurisdictions have also their own restrictions on payments, and the company who supplied the goods might also need to think about how it will receive the funds back to Ukraine or somewhere else, to another jurisdiction, and think of of the structure of this transaction and how this business should be organized. And then we go to the third layer of analysis and help that the companies wanting to participate in procurements need to think about. This is the procurement laws itself and procurement legislation. So I wanted to mention here that we discussed a lot about EU procurements and taking it like something general, but the EU directives on public procurement, they are implemented in each member state. And also they should be implemented, let's say, in an identical way, and in many cases they have been just translated, let's say, and approved. Sometimes they have been implemented into the legislation and have certain types of differences. Also, they have different procedures on challenging the bids, challenging the tender results, challenging the decisions. Therefore, if you are aiming to enter a certain market and participate in public procurements, you really need to understand the public procurement regulations, especially on deposits and performance guarantees, which would cost you money, and you would not be able to refund them later on if you already paid the bank for a deposit or for a performance guarantee. Then another issue here is that when you bid for a public procurement abroad, the foreign law applies, and the foreign law would apply also to your procurement contract. This means that if you have the US, for example, procurements, there you just, let's say, accept all the terms that you have in the contract. You cannot actually negotiate a lot in the procurement contracts with the US. If we have EU, there, for example, in Germany, you can negotiate the contracts and negotiate them under foreign law. So actually you are opening negotiations on warranties, on obligations, on liability, on limitation of liability, and this, for this actually you need either to have a consultant, outside consultant, or you have to have a partner, local partner who understands this and can assess your risk and provide you with the best, let's say, options available at these negotiations. All these procurement contracts will be governed by the laws of a particular country. For example, for the EU it will be the laws of the member states. For example, for Germany, German law. As a rule, for Poland it will be Polish law. In the US it will be also, might be also dependent on the tender you're participating in, the laws of the states. So it's quite a lot of knowledge that the company needs to collect and assistance to be competitive and efficient in participating in the public procurements. And another thing that although we have now the process in the EU on promoting electronic tenders in the US, as discussed yesterday, still the procedures at certain level are very formalistic. You may need to supply paper documents, which means you actually need to be present there. You have to have either a partner, a representative office, or a consultant. And to be efficient, you also have to be able to ask the questions on the ground. So you have to have someone who can clarify the tender requirements, who can help you with tuning your bid so that it responds to particular issues. And of course, a lot depends on the goods or services you are supplying. For example, if we say about commodities, it's a little bit easier. If we say about technologies or about works or sophisticated product designed for particular customer, it's way more complicated, and preparation of the bid may take a lot of time and have to comply with many technical details that is difficult to meet from the first time without special preparation or experience in participation. And then a negotiation in the contract, as we discussed, and assistance in challenges and decisions and the results. And what we've seen in practice, we have been approached a number of times when Ukrainian companies lost, for example, the European tender, and said that we complied with all the tender requirements, so please have a look at the tender documentation, we want to challenge it. And when you look at the tender documentation and at the bid, you really understand that because of differences in legislation, Ukrainian, European, and in practice, the companies misunderstood the tender requirements. And it's obvious if you look at as a foreign specialist, or a foreign specialist look at it. For example, the guarantee is not a proper guarantee, certain terms do not correspond, and challenging at this stage, if you go for challenging without proper preparation, it's really difficult. However, if the case is good, we have especially cases in the US when the public challenges of public tenders have been very successful, and the companies won the bids. So after actually losing them, so it's all possible. And I want to encourage here the companies and the consultants to determine first the markets they're interested in, and not to go shooting any, let's say, procurement, but to define where they are competitive and really take a good preparation and participate. Ukrainian companies have very good chances in winning if they are well prepared, and good chances in even challenging the results if they are not, let's say, as they wished to, if they are well prepared for the tenders. And another thing, last year, I made a similar presentation on this GPA, on public procurement, and there were not many companies that were actually, we didn't have many cases when companies were preparing to enter the market, or did the research, or started to research the labeling, packaging, and all the requirements on the logistic, how to organize the supplies. And this year already, I know that many companies are looking into foreign markets and really get prepared and starting to change their products for particular markets they are interested in, and finding partners to participate in procurements and bids. So I hope that the next year, if there will be any conference like this, we will have many participants who already won the tenders, at least in certain jurisdictions. So have good luck, and thank you for your attention.